Can you see those? Oh, there's 2 votes.
Let me try.
Do you see IMF holding crypto assets in the future? Oh, they're over here. That's easier. You want to take one? Go for it. The first one's for you. IMF. Do you see IMF holding crypto assets in the future? I did not put that up there.
Remember, I'm from the legal department. I'm supposed to be very conservative about these things. I don't want to go into great details about
Maybe
the IMF.
I should take what the IMF is going to do. I think we stunned Ross into silence with that one.
In a Twitter war with Bitcoin maximalists, Pano Mekras defended XRP against centralization and irrelevance allegations by emphasizing the widespread use of XRP. I was wondering if the SEC has to be fair under US law. Last but not least, was Ripple's XRP ownership a factor in the SEC case? If you want to know more, you'll have to follow us until the end. Welcome back to my channel where we discuss recent developments in the world of XRP and other cryptocurrencies. We'd like to extend a warm welcome to everybody who is checking out one of our videos for the first time. If you don't want to miss any of our videos, be sure to enable notifications by clicking the bell, and don't forget to support my channel by pressing the subscribe and notification bell. Author of Understanding the Crypto Economy, Panos Mekras engaged in a Twitter war of words with Bitcoin maximalist and influencer Vlad Costa about the value and legality of XRP, the 6th largest cryptocurrency by market size. The controversy began when Vlad Costa launched a devastating attack on XRP, characterizing it as a coin issued by a central bank with diminishing value. She was taken aback by XRP's continued market dominance and explained its success by unit bias and the false belief that it was connected to the banking industry. Mekras, who is a prominent member of the XRP community, has criticized Costa's claims as absurd, drawing comparisons to those who believe in a flat earth. He was dismayed to hear that such falsehoods persisted in today's age of abundant online data. Mekras cited his paper, Why XRP is the Most Misunderstood Cryptocurrency, as evidence in which he examined Xrp's technology in detail and dispelled popular misconceptions. He also tweeted on how XRP's public blockchain and open source code contributed to the currency's decentralized nature. Mekras also mentioned how widely XRP is being used, with the XRP ledger serving as a foundation for hundreds of projects and tens of use cases. He suggested that anybody interested in learning more about how XRP could be used visit the official updateXrp website. Mekras cited his earlier tweet in which he argued that XRP is for everyone and was developed to break up banking monopolies in favor of a more accessible and decentralized mechanism for making and receiving payments. Importantly, the discussion between Mekras and Vlad Costa is only one example of the many debates on XRP's decentralization. Ripple's CTO weighed in last week on a debate regarding whether XRP is truly decentralized enough. After the Hyman drama, Ripple's general counsel Stuart Elderody revealed a fascinating tidbit concerning the legal obligations of SEC employees. Elderody claims that the law mandates objectivity on the part of all federal employees, particularly those working for the United States Securities and Exchange Commission. The legislation asks whether or not an objective observer would have grounds to doubt the worker's objectivity given the information at hand. The Ripple General Counsel further mentioned that the public is now aware of the truth. He also brought up the necessity of public duty. Notably, this part alludes to the universal truths that apply to every worker and serve as potential bases for behavior. The first part states that federal employees must put the Constitution, ethical ideals, and the law ahead of personal gain, since public service is a public trust. Ripple's General Counsel also cited a section that says government employees should avoid doing anything that could give the impression that they are breaching the law or the ethical standards set forth in this part. A reasonable person familiar with the facts should be used to decide whether or not a situation gives the impression that a violation of the law or these standards has occurred. Important previously unknown information regarding the SEC has been uncovered as a result of the current Ripple case. You may recall that in the Ripple case, the United States federal judge Sarah Netburn called the SEC's litigation strategy hypocritical According to news coverage of the legal battle over Heineman's files, the SEC's first position was that the speech didn't contribute meaningfully to the market's understanding of whether or not the Commission will regulate cryptocurrencies after being defeated in court. The SEC continued to insist that the documents are shielded by attorney-client privilege on the grounds that Heineman had consulted the SEC's lawyers before delivering the speech in question. In light of these competing assertions, the judge concluded that the Commission is taking its legal position for political rather than legal reasons. Heineman's speech from 2018, in which he characterized cryptocurrencies like Ethereum and Bitcoin as non-security, is referenced in the accompanying documents. During his talk, Heineman mentioned that once a token has reached a certain level of decentralization, it would no longer be considered a security. Industry leaders, however, say the documents prove the controversial Heineman speech was intended to clear the way for Ethereum. Heineman sent out an email with the subject line "The Ether Speech" as he was writing the speech. A few days before his lecture, the former SEC director also met with Vitalik Buterin, the founder of Ethereum. As a result of these disagreements, some have suggested that Heineman may have been compensated for his remarks. In light of the ambiguity surrounding Heineman's June 2018 statement, Ripple has requested that the proper authorities conduct an investigation. Pro-XRP attorney and crypto law founder John Deaton recently discussed the potential implications of a U.S. safe harbor proposal in a Twitter discussion. According to Deaton, a safe harbor proposal like the one presented by SEC Commissioner Hester Peirce would have given token issuers a grace period to develop their network free of federal securities laws under certain conditions, which could have prevented the legal battle between Ripple and the SEC. To highlight the SEC's major concern, Deaton said that a particular time frame for Ripple to lower its holdings and achieve the predefined threshold should have been set if the regulatory body had focused on Ripple's percentage of ownership in the outstanding XRP. Deaton made these comments out of his firm belief that the United States has lagged behind the rest of the crypto environment due to the lack of clear norms and a safe harbor structure. Deaton used a meeting between Andreessen Horowitz representatives and former SEC Director Bill Heineman on March 28, 2018, to emphasize the significance of a safe harbor proposal. He emphasized that 16s had written a lengthy paper suggesting the safe harbor prior to the meeting, which was designed for Ethereum, but could be applied to other tokens as well. Deaton speculates that this specific safe harbor idea may have inspired Commissioner Peirce's submission of a similar proposal in 2020. In April of 2021, she submitted a revised plan with those alterations. Deaton argued that crypto businesses like Ripple and LBRY would have benefited greatly from a safe harbor strategy. These businesses might have gotten a notification describing the particular criteria needed to demonstrate decentralization, and they might have had 3 to 5 years to do so in order to establish their tokens as commodities. Deaton admitted that not everyone would have been happy with the proposed guidelines, but a well-defined framework would have encouraged innovation and regulatory compliance by allowing companies like Ripple to work towards meeting the requirements within a specified time frame. Deaton claims that the ongoing legal conflict between Ripple and the SEC is due in part to the absence of a safe harbor proposal and the lack of defined rules regarding token ownership. Ripple's unilateral choice to lower its XRP holdings to cover its legal fees was mentioned by Deaton as proof of Ripple's dedication to defending itself against the SEC's charges. Guys, I think we will have to stop here for today. If you have any business proposals, simply send us a message via the email or Telegram provided below. And don't forget to press the subscribe and notification bell. Thank you for watching.